One of the other things that we struggled with in the legalization of 86 was the confidentiality provisions that precluded us from sharing the information that an applicant provided with other law enforcement agencies or within our own organization. And I understand the intention of that was to protect the individual and encourage them to feel safe to come out from under the shadows and to apply for lawful status, temporary lawful status. I understand that. But the problem, my experience with that, and I hope we don't repeat that with the next comprehensive immigration reform, is that you don't really want to protect individuals who are criminals. And if an individual provides fraudulent information or is engaged in criminal activity, I just can't appreciate why we would want to protect that individual. In fact, I know this may seem a little bit draconian, but I think it's objective and fair. I think that if an individual applies for government benefit, particularly amnesty or legalization, that if later we find that it was fraudulent in nature or that they've been engaged in criminal activity prior to that application and they didn't disclose it, I think that information should render them immediately ineligible and lose their status and facilitate the expeditious removal of that individual. I just can't, I hope they don't have the same confidentiality protections. Now there's a way to limit that with regard to the egregiousness of the criminal activity, but I'll go back to the fraud, and I would apply this across the board to any application and petitioner, that if someone engages in fraud, whether it's an applicant, a petitioner, a beneficiary, or people help them, to include attorneys, immigration and other attorneys and organizations, community and otherwise, whoever was associated with that fraud, once it's proven, they should not be able to apply, seek an immigration benefit for a to be determined number of years, and they should be required to pay a fine. What happens now is the laws tend to focus more on the beneficiary and the applicants and not the petitioners and the others. Now, I finished talking about how the overwhelming majority of fraud is investigated by CIS through its FDNS, and their administrative investigations, not criminal. So most of the fraud isn't prosecuted. So we are chasing our tails, so to speak, if we tolerate the fraud. We are in effect silently encouraging it, and we can't do that. So we do need a provision, and maybe in comprehensive immigration reform it addresses that for amnesty, legalization, and the rest of the application world, which is if you commit fraud, you cannot file a petition or an application for, say, 5 years. You must pay a fine of X amount. And at the end of that period, you must also, before you apply for permission to reapply, you have to demonstrate rehabilitation. And if you didn't pay the fine, there's interest accumulated, and you help collect the money and then some, not just fund the process. That's how I would do it. Now, I know certain people, when they hear me talk about information sharing collaboration with the law enforcement and intelligence community, will make the hair on their neck stand up. And they're thinking, oh my God, Big Brother, Privacy Act. You're sharing information on foreign nationals that is personal, private, and does not warrant disclosure outside of CIS. And, you know, to a great degree, I can understand that. And the Privacy Act is there to guide us accordingly. So we are most certainly supporters of the Privacy Act. But I'm not talking about that kind of information. What I'm talking about is when you get information, whether it's a result of a background check, fingerprint, biographical information, just a check of a law enforcement system, or information in the file is linked to some other national security or criminal investigation, or your anti-fraud case links on to another major investigation by another agency. And if it happens to be national security, and there are certain criteria with regard to when the information is releasable, whether it's for a law enforcement purpose or a national security intelligence purpose. So we're well aware of all that, and we filter the request for information and the information that we release accordingly. But if I could, I think that needs enhancing as well by Congress. Because there are some that are so fixated on not sharing information that by the time you go through this filtering process, and it could take so long, by the time we get that information to the appropriate agency, the action has already been taken. I think we need less of that, and we need a clear law with regard to what criteria is released for law enforcement and national security and intelligence purposes, and then the guidelines and who's responsible. And maybe we need one system that tracks all that, so that you can track the requests, you can track the information. There has to be a better way. It just isn't being done as effectively as it needs to be. And we need to get that information to the enforcement intelligence community much more quickly than we can.